Welcome to Making the Case. I'm Yodit Tewolde. Today in Brunswick, Georgia, the judge presiding over the case against the three men accused of murdering Ahmaud Arbery made several decisions that could impact the trajectory of this case. His rulings come as jury selection continues to crawl forward. BNC's Dre Clark has today's developments from court.
The judge was very clear today that the group has a right to peacefully assemble on the courthouse lawn behind me because it's a public space.
If you think you've seen it all, keep watching us.
Not backing down, not giving in. Members of the Transformative Justice Coalition can keep demonstrating outside the Glenn County Courthouse. Defense attorneys for the three white men accused of murdering Ahmaud Arbery in February 2020 asked the judge to remove the group, arguing their signs and banners supporting the Arbery family are negatively influencing potential jurors walking into the courthouse. But Judge Timothy Walmsley denied the motion, saying, quote, "The court does not find the defense has met its burden," while also noting the coalition has free speech rights.
It's a shame that they're so desperate, so depraved in their thinking about how to actually proceed with a very difficult case for them.
It's an act of desperation. It clearly is.
Defense attorneys have also raised concerns about Ahmaud Arbery's father being inside the courtroom. Monday, defense attorney Kevin Goff said he watched Marcus Arbery Sr. nod at a prospective juror as they left the courtroom after questioning. And in the first week of jury selection, Arbery Sr. was accused of giving another prospective juror a thumbs up. He feels like he's being targeted.
Does that hurt? Does it bother you?
No, it don't bother me at all. You know why it don't bother me at all? Because I'm here to get justice for my son, and I got that right. As a father, I got that right because he's silent now. I'm his voice.
Judge Walmsley also expressed concern that outside parties are trying to influence the public and possibly the jury pool. The judge mentioned a tweet written by attorney Lee Merritt. Merritt is representing Ahmaud Arbery's mother in a separate civil case. In the tweet, Merritt questioned how a female juror was qualified to serve even though she has ties to one of the defendants. And he wrote the prospective juror campaigned for the re-election of former Glenn County District Attorney Jackie Johnson, who has been indicted for judicial misconduct. It's alleged Johnson tried to help the defendants cover up the Arbery shooting.
My role as the civil rights attorney for the estate of Ahmaud Arbery is to serve as a constitutional watchdog. I believe that behavior is constitutionally violative, and I would be open to any legal maneuvering to address that concern.
Ahmaud Arbery's family and members of the Transformative Justice Coalition both believe the defense is trying to look for grounds for mistrial. But they say no matter what, the evidence overwhelmingly suggests and shows that the three white men charged with killing Ahmaud Arbery should be found guilty, no matter who is chosen to sit on the jury. In Brunswick, Georgia, I'm Dre Clark for Making the Case.
Jury selection was initially expected to take about 2 weeks. Today, one of the defense attorneys said it's likely that they'll reach a count of 64 prospective jurors within that time frame, which would be this Friday. Only then will they start narrowing down that number to 12 jurors and 4 alternates. With me to discuss today's developments, veteran prosecutor and BNC's legal contributor Paul Henderson and former U.S. Attorney for the Middle District of Georgia and now partner at Moore Hall in Atlanta, Michael J. Moore. Good seeing both of you tonight.
Good to be with you.
All right. Let's start with one of the headlines today. The judge shut down the defense motion to ban demonstrators from the courthouse grounds. Dre mentioned that the judge said the defense didn't meet their burden of proof and also noted that there had been very few demonstrators outside in recent days with no reported issues or concerns. Not to mention those demonstrating are on public grounds, so they're protected by the First Amendment. You know, there's that. Paul, defense attorneys are going to do what defense attorneys do, right? But it seems hypocritical when those same attorneys making the argument that these demonstrations could unfairly influence or intimidate prospective jurors are also making the case in the media, doing interviews and making statements that could have the same effects.
That is absolutely correct. And what I'm proud about, that in this case, they made the argument that they were going to make, but I'm excited that the judge went out of his way to explain his ruling, just denied. And that's essentially going to block them from making the same arguments later on when they try to declare a mistrial, to say that this jury that ultimately will be selected was unduly influenced, because the judge made it very clear that they were not being influenced by what was happening outside, and rightfully pointed out that he had a reasonable basis for denying their motion by articulating that they have their First Amendment rights and can be out there anyway. And so it is ridiculous that we get criticism like this from the defense bar while they act in the way that they do in a case like this. But I'm optimistic because of the way that the judge ruled in this case. So.
Now, the judge did have a warning about other outside influences after another concern was raised by the defense. They cited a tweet last night from attorney Lee Merritt, who represents Ahmaud's mother in a separate civil case. In the tweet, Lee questioned how a female juror was qualified to serve and specifically brought up some of her past work experience, something the judge has warned the media and other public officials and figures not to do. Now, Lee, who responded in Dre's piece, said that his role as counsel meant he also acts as a watchdog. Today, the judge said no matter who it is, he's concerned by any attempt by third parties to get out information that could reach the jury panel. Michael, should there be a gag order on all of the attorneys involved? I mean, I understand Lee's point, but I also understand the judge's concern for prospective jurors who may not even make it onto the jury panel. And there have been clearly some statements made by some of these prospective jurors about the concern that they have considering cancel culture, the retaliation that people seem to take when, you know, you're talking about such a high-profile case like this. This is sort of speaking to the environment that we're currently living in, correct?
It really is. You know, Brunswick is a fairly tight-knit community. And I do know that there are jurors there who have been summoned to come serve that are fearful of what may happen no matter which side of the case they come down on after they hear the evidence. So they're afraid, like, why would I want to uproot my life? Why do I want to have to move? Why do I want to have to face ridicule if I go to the store? So I do think that's a very real concern. You know, as to the lawyers speaking, I'm surprised at this point that there's not just a standing gag order in place. You know, people have a right to get their message out, but sometimes during a trial, it's more important that we guarantee that both sides have access to a fair jury. And I don't, you know, Mr. Merritt may be counsel for the estate, but he is not counsel in this case. And so that tells me that maybe he shouldn't consider himself the constitutional watchdog of this trial. There'll be a time for that. He'll have an opportunity to proceed in his civil case. And the same thing, I think the judge absolutely made the right call on the protesters and the demonstrators out front. I mean, they absolutely have a right to be there. And frankly, but for people who had some courage to protest in the first place, the trial wouldn't be going forward. So, you know,
Precisely.
We have to acknowledge that, recognize it at the front of it. So, but I do think there are ways to do that. And sometimes, you know, standing in silence is the loudest message you can send, and then nobody can object. It's say that your chanting or your comments might influence jurors as they're walking in. It's just that your presence is there. It's felt in a way that sometimes, you know, even the loudest shout is diminished by, you know, just being there. And so, you know, I would hope that the people who are maybe helping organize and who are moving forward really recognize that what's important is to make sure that this trial moves forward, that there are no glitches, that there's nothing to turn around and maybe have some appeal issues on, but you can still be heard. And again, your presence is just speaking volumes and loudly to the nation.
Paul, there was yet another request from the defense. This one was granted, at least in part. They requested permission to ask additional questions of prospective jurors, to which the judge granted two. One would allow attorneys to ask about people's position on the Justice for Ahmaud campaign. The other allows them to ask if prospective jurors will follow the law that's given to them by the court, even if they think the law may or should be different. The judge didn't approve of the questioning prospective jurors on whether they wanted someone like themselves on a jury if they were the defendants. The judge was concerned that the question could be racially charged. I understand that ruling, but I don't really understand why it was necessary to have a separate hearing and ruling for the other two questions that I think were appropriate. No?
Well, I understand. I think I understand what's behind the rulings in those cases is that organization, the judge presumably deemed too close to the issue that he thought it would be improbative to have jurors answer that question just because they supported or attended an event or maybe even were members of that organization. Did they have a preconceived notion predetermining the outcome from this trial? And so that's why he asked that question. But, I think it's a really tough call in a case like this where the facts are being what they are. It's such a clear and obvious thing as to what happened. We all saw it. All of the jurors all saw it. The fact that some of them may have been inspired to work against the travesty that they saw in that video is a separate issue, which is why I think we have the second question, which is whether, and I think that that's a restorative question that he is allowing to be added on whether or not, despite what their previous answers are in any of the other questions, whether they can be fair and impartial and hear the evidence. And that, to me, is a nod towards the prosecution to allow them to rehabilitate and keep some of the jurors that may have been supportive of Black Lives Matter, that may have made statements supportive of Ahmaud Arbery, that may have indicated their awareness about race disparities. And in spite of those things, they're still able to be good jurors because the race disparities and the race issues are facts, but what complicates this entire race in new ways. That's why the judge is giving it so much leeway to make sure that he doesn't get overturned later by selecting this juror.
All right, Paul, Michael, you guys sit tight. We've got more of what these prospective jurors had to say today, including one who was strategically trying to get out of serving on this jury when making the case return. We're back with former prosecutors Paul Henderson and Michael J. Moore as we continue our discussion on week 2 of jury selection in the trial of Gregory McMichael, Travis McMichael, and William Bryan, the 3 white men charged with the murder of Ahmaud Arbery in Georgia. All right, let's pick up our discussion with prospective juror number 466. We know this is a white male whose wife has a professional connection to someone in the McMichael family, but when it comes to discussions about the case with friends, family, coworkers, and his spouse, he said, quote, "I usually don't let people shape my opinions." He also said this: "I have a feeling there will be a large protesting presence here in the next couple weeks, and should my name somehow slip out into the ether, I don't worry about my well-being, just them," referring to his spouse and child. Michael, you told my producer about how this sort of response is symptomatic of the times we're living in. People used excuses all the time to get out of jury duty, but now we seem to have come up with a new one, and that's the fear of cancel culture. But jury selection is such an important component of a jury trial. How can we turn this tide, or can we?
I do think it's a shame that, especially in the last 4 or 5 years, that we've gotten to a place where violence and intimidation and threats are how we have become the norm, I guess, in public discourse, and I think that's a tragedy. But you're right. The jury is an integral part of the system, and they need to be there, and they have a right to be there and a duty to be there. I hear that the response that was given by that juror, and I almost want to applaud them for some amount of candor, because I'm sure that's probably going through a lot of people's minds, is what happens, if I'm selected. They have memories like the O.J. Simpson case, where trials last forever and ever. They have, other huge cases that have happened across the country, and jurors have been questioned or harassed at some point. And that's probably a concern that they've got to work through. But the judge, that's his job. He needs to keep the case moving. He needs to make sure that the lawyers are not overblowing the case, because at the end of the day, and Paul said this, there's a tape of this. This is not a secret whodunit case. We've actually got a tape. And this case is about, why did they do it? And are they going to be able to claim some amount of self-defense? And, they're going to have to walk this fine line, the lawyers in the corridor, about how do we deal with race, which is going to be an issue in this case. And anybody that suggests that you could take race out of this case, now the jury selection process and those feelings, it's about like trying to take, Christmas trees out of Christmas. It is not going to happen. And then the question is, how do you deal with it? And so whether it's prospective jurors, whether it's, arguments made by counsel or outside statements, it's the court's job to keep this moving, to make the jurors feel some degree of comfort when they, if they're selected, and actually, and we have to applaud them even for showing up en masse for this panel.
All right, let's look at juror number 479, a black woman who was the only person from today's panel who raised their hand indicating they wanted to serve on this jury. As expected, both sides spent some time grilling her on exactly that. When the prosecution asked her why she wanted to be on the jury, she said, quote, "I believe I can bring peace out of the storm, and we as a community are supposed to love one another." When the defense asked how serving on this jury would achieve that, she said, among other things, "I am trying to do what is right, whatever is right in God's eyes. I don't know these men, and I don't know the young man." Paul, several red flags here for me. Besides her wanting to be on this jury, her saying whatever's right in God's eyes is an issue. Listen, I love my Lord and Savior, but he has no place in a court of law when you're presenting evidence to a jury, right? Whether your God may want a certain outcome or not, again, you can't present that to a jury and ask them to decide based on that. Your thoughts?
You're 100% correct. And I would have flagged that as the juror was making the case and asked a series of follow-up questions that I would want to know if you're going to raise that issue about following the Lord or listening to the church or being guided by your spirituality. Well, that's a third factor, because you've got the facts, you've got the evidence, and then you have this interpretive spirituality or religious interpretation that would be difficult to gauge without more questions. Is your judgment superseded by your spirituality? And then you have to unlock the Pandora's box of what are your beliefs and what do your religious influences tell you about accountability, about murder, about race, independent of the race that she obviously brings to the analysis. And so, yeah, answering a question like that always opens up the door to that much more. And in a case like this, there are so many time constraints because of the volume of witnesses that you still have to go through, and the volume of jurors that you still have to go through. So that would raise a lot of questions, but would make me nervous because I wouldn't want to guess wrong to interpret what she meant by following the Lord or following her spiritual beliefs while she determined a very important case like this.
All right, on to juror number 475. We know this is a white male who said he's talked to people who know at least one of the defendants and knows at least one of these defendants and, quote, heard every opinion from totally innocent to totally guilty. He said he and his wife watched the video and researched laws, but he also said he and his wife worked together on his juror questionnaire and they were trying to avoid getting picked. Michael, again, red flags for me with this prospective juror. Not his admission that he was trying to get out of serving on this jury. I mean, I could appreciate his honesty, but it's the me and my wife researched laws. Me and my wife worked on my questionnaire. It seems like his wife would be an influence on him. I mean, if he were to be picked as a jury, I could see him going home and discussing the evidence with his wife, which is something jurors cannot do. Yeah,
she's going to be shadow juror number 13 if he's picked on this case, and that is he's going to go home and say, look, are we making the right decision? This is what we heard today. What do you think? And she likely would not be sitting in the courtroom, so she wouldn't have heard anything. And so anything she said was probably tainted from the media that she happened to pick up, which you shouldn't be talking with her about it anyway. So I agree with you. It's a red flag. It would cause me some heartburn if I was trying to pick this juror. I appreciate the honesty about I didn't want to be picked. I mean, you want to know that, and that's why lawyers have strikes. I mean, each side has a certain number of strikes they can use for a group if the juror's not removed for cause. So, but jurors are told, don't talk about this, don't watch the news, don't read the newspaper, don't look at Facebook, whatever the case may be. And that kind of goes back to the first topic we talked about in the last segment, and that is, there probably ought to be a gag order to sort of at least prevent some information from potentially tainting this jury pool.